case, and then my co-counsel will focus on the merits. Honorable Tribunal. The contract in the case at hand is a result of lengthy negotiations between the parties, especially with regard to the arbitration clause. Both of the parties have agreed to the narrow wording of the clause and have impliedly chosen the law of Danubia to govern it. Nevertheless, the claimant, in light of its potential insolvency and as a last resort, tries to put the cart before the horse and convince the arbitral tribunal that it should adopt the contract. Therefore, the respondent's submission will be made in three main points. That firstly, the parties have impliedly chosen the law of Danubia to govern the arbitration agreement, and therefore, the arbitral tribunal is not empowered to adopt the contract. Secondly, that even if the tribunal finds otherwise, still under the law of Mediterranean, it is not empowered to hear the case at hand. And lastly, that the evidence that claimant intends to submit shall be rejected by the arbitral tribunal. Moving to my first submission, I would like to kindly ask this tribunal to follow the wording of the arbitration clause, which is to be found on page 14 of the case file. In clause 15, the parties have included the arbitration clause, which is largely based on a Hong Kong model clause and provides 3 out of 4 optional suggested additions to be provided by the parties. The clause provides that the seat of arbitration shall be Danubia, the number of arbitrators shall be 3, and provides English as the language of the proceedings. The only one addition missing, suggested by the Hong Kong Center, is the one regarding the law applicable to the arbitration agreement. However, as there is no explicit choice with regard to that issue, there is a need to take into consideration whether the parties have made an implied choice concerning the law applicable to the arbitration clause. In the course of the proceedings, the respondent provided very similar offer concerning the arbitration clause, whether the body will remain unchanged, and in the proposal, which is to be found on page 34 of the case file, and I kindly ask this tribunal to follow that page, 33, my apologies. In that proposal, the respondent provided with the claimant that the seat of arbitration shall be Ecuadoriana and Ecuadorian law shall be the law applicable to the arbitration clause. Ecuadoriana is the respondent's place of business. The two additions, as it may be seen, concerning the language and number of arbitrators remains the same. The claimant largely accepted the respondent's proposal, and I kindly ask this tribunal to follow the next page of the case file, that is the claimant's answer to that proposal. The claimant, and I quote, largely accepted the proposal with an amendment as to the place of arbitration.
Where are you quoting from?
This is the paragraph 3 of the claimant's email on the page 34.
Right.
We would and I quote, we would largely accept your proposal with an amendment as to the place of arbitration so that the clause would read in its relevant part. Therefore, the claimant has remained silent on the issue of the law applicable to the arbitration clause. However, such silence on that issue cannot be in any case regarded as the claimant's intention to apply the law of its own place of business and the law of the principal contract to the arbitration clause. Logically speaking, there are only two possibilities on what that silence could actually imply. The very first would be that the claimant agreed that the arbitration clause shall be governed by the law of Ecuadoriana, that is the respondent's place of business. And the second one would be that the claimant must have been aware of the fact that the altering the seat of arbitration would result in altering the law applicable to the arbitration clause. The very first implication in favor of Ecuadoriana would be nevertheless contrary to the claimant's own internal policy, as it would require the claimant's creditors committee approval to subject dispute resolution clause to the law of the counterpart.
Should the panel interpret the agreement between these two parties by reference to what was internal to the claim?
Could you please rephrase the question?
Should this panel consider the true construction of the arbitration clause by reference to matters concerning one party only?
With regard to the to determining what law should be applicable to the arbitration clause, whenever there is no explicit choice of the arbitration clause, the tribunal is requested to take a look whether there is an implied choice.
Yeah.
And therefore, all information exchanged by the parties shall be taken into consideration.
Right. Exchange between them.
Yes.
Yeah.
And the claimant has informed the respondent that subjecting dispute resolution clause would require the creditors committee approval.
Right.
Therefore, it is our client's submission that the claimant's the claimant's silence on the issue of the law applicable to the arbitration clause shall be regarded as awareness of the fact that altering the seat of arbitration will result in altering the seat of will result in altering the law applicable to the arbitration agreement. And with regard to my second submission,
before you get to that, please, can you just help me? So why wouldn't the governing law of the arbitration agreement be the same as the governing law of the main contract?
could you please rephrase the question?
So the governing law of the main contract is the law of Mediterranean, but I think as I understand it, you're arguing that there should be a different that governing law should not apply to the arbitration agreements as well. Why is that in your submission?
This is our client's submission that the parties' intention and all surrounding circumstances indicate that the parties have been aware of the fact that altering the seat of arbitration will result in altering the seat of altering the law applicable to the arbitration clause, as it is judicially regarding these two laws more and closer connected with each other than the law applicable to the principal contract.
And do you have any authority for that proposition?
In Sul America case, the judge concluded that the law of the lex arbitri has the most and closest real connection with the law of arbitration agreement than the law of principal contract.
Thank you.
Moving to my second submission, even if this tribunal finds that the parties have impliedly chosen the law of Mediterranean to govern the arbitration agreement, still it is not empowered to adapt the contract. The Mediterranean is the claimant's place of business, and in the course of negotiations, the claimant has suggested arbitration in Mediterranean. Also, under the Mediterranean law, a standard arbitration agreement is regarded as empowering the arbitral tribunal to adapt the contract. However, the arbitration agreement concluded by the parties is largely based on a Hong Kong model clause. However, the parties has removed from that model clause the part stipulating that non-contractual obligations are within the jurisdiction of this arbitral tribunal. Therefore, it is our client's submission that the parties have narrowed down the arbitration clause in order to exclude from the jurisdiction of the arbitral tribunal the possibility and the remedy such as a contract adaptation. And with regard to my third and last submission, that is the evidence. That is the evidence that the claimant intends to.
Sorry, just before you leave that, Sarah, was there anything else you want to raise on the first point? The first submission?
No.
Good. Yes, thank you very much. Yes, let's move on to the second.
I would like to kindly ask this tribunal to reject the evidence that the claimant intends to submit.
Do you mean rejected as a matter of fact or declared inadmissible?
We would like to kindly ask to declare that it's inadmissible.
Right.
The very first reason why the evidence shall not be admitted by the arbitral tribunal is the claimant's involvement in the obtaining the evidence. The claimant will most likely argue that it has not been itself directly involved in obtaining the evidence. However, the claimant, after receiving information concerning the other arbitral proceedings and being aware that the other arbitral proceedings are conducted in accordance with Hong Kong rules, which impose strict confidentiality obligation, decided to pursue the evidence and contacted the company providing intelligence in the horse industry in order to pursue and to buy the evidence. Therefore, the claimant disregarded confidentiality obligation and procedural fairness between the parties. Also, with regard to materiality of it.
So how does procedural fairness come in here? You said they disregarded the confidentiality obligation and procedural fairness. How is procedural fairness relevant?
The claimant has decided to buy the evidence, being aware that the evidence is intended by the other parties to remain confidential, and this is our submission that such behavior, such conduct should be regarded as infringement of procedural fairness between the parties.
Between the parties in this arbitration or
between the parties in these arbitration. With regard to materiality of the evidence, it is our client's submission that the evidence is not crucial for the outcome of the arbitration, as there are several and significant differences between the two cases. In the other case, the law of the principal contract may be Mediterraneo indeed. However, the lex arbitri is also the law of Mediterraneo, and also the parties in their contract included ICC hardship clause, which provides for termination of the contract. And in our case, the remedy that is provided by the parties is simply exemption from liability.
If we were to exclude it, as you would wish, what would you say about the quality of our decision making on these facts?
If the evidence was admitted.
No, it is excluded. It's excluded. Do you say that the tribunal could reach a proper decision?
Indeed, Mr. Presiding Arbitrator, the claimant has other means to prove the respondent's intention regarding the threshold, which constitutes hardship, that is the respondent's intention or the reasonable understanding as the contract is subject to CISG. So on that basis, the tribunal is able to reach a proper decision in this regard.
Right, well, you may be coming to the end of your submission, but I think you've had your time.
Yes.
Thank you very much indeed.
Thank you very much.
Yes, Yamas.
Good afternoon again, the members of the